turn our attention now to the subject of common law guarantees. Now, firstly, a word of warning here. When we were talking about contracts in general, I was saying don't be worried about not being a lawyer if you're involved in the negotiation of the drafting, because there are no special words or phrases that have special legal meaning. But when we turn our attention to guarantees, the advice is the exact opposite. Guarantees are full of voodoo words and phrases, words that have special legal meaning. And therefore be very careful. If of course you are the lender negotiating the guarantee, if you're the guarantor, then I'm sure you're delighted if certain aspects of the guarantee are unenforceable. Always reserve your rights and get special advice. When we go through this clip, I think you will know where all those special words and phrases are. The issue is whether you remember that in 10 months' time when you find yourself in the middle of an actual real-life negotiation. The reason that this has evolved, you'll remember that common law is based on case precedent, stare decisis, and over the centuries, in the case of loan agreements, the courts have always favoured the lender. The borrower has lost the money, there is no excuse, there is no defence. Whereas guarantees, that's not the case. The guarantor has not lost the money. The lender may be more at fault for the financial loss than the guarantor. And over the centuries, the courts have leaned very heavily in favour of the position of a guarantor. There's an old saying in law, the guarantor is the darling of the courts. And so there have evolved, over the many years, dozens of ways to get out of a guarantee. Now, because of case precedent, bankers or lenders know what all those exit routes are. And that's why a guarantee is not 2 sentences long. Why can't we have a guarantee that just says, in respect of the underlying financial obligation, I hereby guarantee the performance of the underlying obligations? Because within 2 or 3 months, the guarantee almost certainly will be unenforceable. As we go through this guarantee, you'll see that almost every clause involves the shutting of yet another exit door. Okay, now the guarantee that I've chosen to go through our discussion is the one that I'm showing up on the screen. It is a real-life guarantee. The reason I'm choosing this one is it's very succinct. It's very short, to the point. There are no admin type clauses here, sort of what if you pay in one currency and the underlying obligation was in a different, and how do you convert? All of that's administrative. I'm going through the key clauses that contain liability. And in the notes, I then have provided a reconciliation between this very short 2-page guarantee and the one that is embedded inside the LMA syndicated loan agreement, so that if you understand the issues that we're talking about in this clip, you'll be able to trace them with that cross-reference. Okay, well, let's make a start. Now, the guarantee starts off with the words "in consideration of." Well, of course, we all know that for a guarantee to be legally enforceable, it must be a contract. And amongst other things, for it to be a contract, there must be good consideration. It's not a requirement of English law that you state what the consideration is, but it is good drafting practice to start off a contract with the words "in consideration of," because it causes you to think, actually, is there consideration on the facts of the individual case? Remember, in financial transactions, when you are reorganizing a financing of a company perhaps in distress and there's no event of default, you're not advancing new money, but you are taking a new guarantee, it is highly probable that there will be no consideration. And therefore, either you have to execute the guarantee as a deed, which doesn't require consideration, or you need the magic $1 clause in consideration of the receipt of $1, receipt of which is hereby acknowledged. So even if it's a $100 million guarantee, the fact that you paid $1 for it makes it legally enforceable. Otherwise, it's a gift and therefore not enforceable at law. Okay, in consideration of the bank having giving or having given advances, well, past consideration is not good consideration. And therefore, it's not a problem that someone has written this nonsense, but do remember there has to be a nexus between the two things that are given. The giving of the guarantee and the giving of the loan, or the giving of a waiver of default, or something of this sort. We insert the name of the borrower, who's in this document is going to be called the customer. We insert the name of the guarantor. Hereby guarantees payment on demand. Okay, there's the first voodoo phrase, payment on demand. Please don't miss this out. Unlike security documents, which will always have a trigger clause, the trigger is usually an event of default. A lender can only exercise the security if a default has turned into an event of default, with the passage of the grace period, and then, sure, the bank has rights. In a common law guarantee, there will nearly always be no trigger event. That means guarantees are legally enforceable at any time. And therefore they would automatically become unenforceable on the 6th anniversary of the date of their signing. Under the statute of limitations, is 6 years for a normal contract and a statute of limitations of 12 years for a deed. And that 6 years starts running as soon as the guarantee is signed. Now, many guarantees are more than 6 years old, either because they're evergreen. A loan is constantly rescheduled, the maturity is pushed out and out and out, but the document isn't re-executed, the guarantee isn't re-executed. In project finance, some guarantees are 25 years in duration. And therefore, we need to say payment on demand, which means the 6 years statute of limitations only commences once a bank has made a demand under the guarantee. And of course, if a bank delays more than 6 years once they've demanded, then they deserve the guarantee to be unenforceable. Now, if the guarantor is unrelated to the borrower, for example, in a project financing, if you have a special purpose vehicle, and I'm a multinational corporation and I'm in business partnership with a local business, I am not wanting an on-demand guarantee. I am likely to want what's called a shortfall guarantee. In other words, if you're the lender, I want you to exhaust all of your remedies against the borrower, the special purpose vehicle, sell the assets and so on, and only come against me under the guarantee for my proportionate share of the liability of the shortfall. Now, of course, for a lender this isn't very attractive. It may take 2 or 3 years to wind up the affairs of the special purpose vehicle. But of course, like any negotiation, who has the stronger bargaining power. But nearly always, when a guarantor is related to the borrower, as is the more common case, then of course an on-demand guarantee. All present and future liabilities. So this particular guarantee is what's called an all-monies guarantee. It's not a specific guarantee for a specific loan. This is very useful for parent companies to cover the borrowings of their subsidiaries. It means that every time my subsidiary does business with you as a lender, We don't have to re-execute documents and go through board resolution processes and so on. It's administratively very convenient. It's like a master guarantee. And this makes perfect sense because I control the subsidiary both through the shareholders meeting and through the board of directors. What does not make much sense is for a subsidiary to sign a guarantee like this in favour of the liabilities of the parent company. Because if you're a director of a subsidiary company, especially if it's not wholly owned, how can you demonstrate that you've discharged your fiduciary duties if you have signed a blank cheque? You don't control the borrower, the parent, and you may not even be aware of what's going on between your parent company and the particular lender. Now, of course, it wouldn't matter if the guarantor was a PLC or an LTD, in other words, incorporated under the UK Companies Act, because as you'll remember from earlier reading and earlier clips, ultra-vires has effectively been abolished for PLCs and LTDs. But if you are signing an English law guarantee and you're not a PLC or an LTD, you really need to take legal advice as to whether you would, an upstream guarantee to the parent, as to whether you have the power to enter into such a transaction, whether it's ultra-vires. In many countries, under the Constitution and under the company law, you are required to demonstrate commercial benefit for your company, the guarantor. It's not the case in the UK, but it may well be in many other jurisdictions. And you remember, to determine whether it's ultra-vires, English law will look at the company law of the place of incorporation of the particular company. Okay, so this is an all-money guarantee. It covers all present and future liabilities, whether actual contingent, money advanced, current or loan accounts, bills of exchange, promissory notes, guarantees, indemnities, interest, commission, banking charges, or on any other basis. Now, the phrase "or on any other basis" does not mean "or on any other basis." It doesn't mean everything. There is a rule of construction in English contract law called the ejusdem generis rule. If you have a long list of things and then you have a catch-all at the bottom of the list, a bucket at the bottom of the list, and all other things, the width of the catch-all, the width of the bucket at the bottom of the list, is constrained by the width of the list above. If you have a very wide list of things, then "or on any other basis" would have a very wide meaning. If you have a very narrow list, then "or on any other basis" has a very narrow construction. Now, I don't know about you, but I look at that list and it's all loan-related products, bills of exchange, promissory notes, loans, and so on. There are no derivatives in there. And therefore, if you had swaps and options, various derivatives, I'm fairly certain that the interpretation of this guarantee would, if it went to court, derivative exposures would not be covered. If, on the other hand, you had a couple of derivatives in that list, even though there are thousands of different possible derivatives, if you had a list that clearly included derivatives, you had a couple and then "or on any other basis" is almost certainly likely to cover all of the others. Okay. Provided that the amount shall not exceed X amount. Now, in other words, this is an all-monies guarantee, but limited to a maximum amount if you fill in the limitation. Because most guarantees, most lenders don't want their employees to negotiate the wording of guarantees for reasons I explained before. And therefore, most guarantees are pre-printed. In other words, they're standard form documents, foolscap paper, green in colour, with the name of the printer at the bottom of the page, because research has shown that very few guarantors try to negotiate the wording of a pre-printed standard form document. And therefore, that even if your guarantee is meant to be unlimited, that sentence, the limitation, will be there. If it's meant to be unlimited, please obliterate, cross out, and initial, both parties initial the crossing out, to ensure that nobody comes in 2 years' time at a later time and fraudulently inserts a limitation. It's been done, and the limitation has a fairly high chance of being upheld for reasons that you will discover at the end of the clip. Okay, let's get on to clause number 1. I'm not going to read it out, but you can see it on the screen. And if you, this is called the variations clause. Once the money has been borrowed by the underlying borrower, there is a good chance during the life of the loan that we will need, that the borrower and the lender will need to renegotiate some of the terms. Maybe a partial release of security, an extension of maturity, an alteration to the interest rate, and so on and so forth. Now, the moment you do that, your change in the underlying loan obligation changes my liability as a guarantor. You're not entitled to do that without my consent. And therefore, if you change any aspect of the underlying loan agreement, you invalidate my guarantee. And therefore, it's absolutely essential that you have a variations clause, which means that you're getting my consent in advance. Now, the variations clause of all guarantees will be slightly different. This one is as you read it. Other guarantees, they will all cover the normal things that borrowers and lenders have a tendency to negotiate. But if you're doing a heavy restructuring of a borrower, and you're doing special board resolutions, changing it from a private company to public company, and all of this sort of major stuff, just check that it's covered by the precise wording of this clause. Because if it's not, then you have one of 3 choices. If you go ahead, you will invalidate the guarantee because you're going outside the ambit of these precise words, and therefore, step 1, you require the guarantor to re-execute the guarantee as part of the restructuring. Now, if the guarantor is related to the borrower, it's the same human beings you're negotiating with, I'm sure you can get a re-executed guarantee. Secondly, if that's not possible, you have to alter your restructuring to fit these words. Or thirdly, you have to, if that's not appropriate, go ahead with your restructuring, but acknowledge you're going to lose this guarantee, which may not be worth much, it may be worth a lot, who knows. I think there was one example of a lender who tried to help a customer save money by, instead of doing the restructuring, they set it up as a refinancing. On the same day, the old loan was replaced by a new loan with the new clauses and the new documentation. The company then went broke, and the guarantee, which would have been valid had they done the restructuring, was invalidated because a refinancing was not covered by the variations clause. So there you are, a lender who was trying to help their customer lost money as a result. Okay, then we move to clause 2. You'll see that clause 2 says this guarantee shall be in addition to, the in addition to clause. The law of guarantees, strangely, is derived from the law of wills. You probably know that a new will automatically invalidates a previous will, unless, of course, it's a codicil. And then, of course, there is the scope for ambiguity. So it is in common law. A new guarantee automatically invalidates a previous guarantee with the same coverage, or that. And therefore, there is the possibility that by taking a new guarantee, you invalidate a previous one. Well, look, if I'm a lender, I don't want any of my security or guarantees to ever be terminated or invalidated, except with my express consent or express desire. and therefore we insert this clause. I happen to know that Barclays, some years ago, they had a policy that all of their corporate guarantors, they would require them to, or they would request that they re-execute the guarantee every 2 years. Because here's a major feature of difference between a common law guarantee and a civil law guarantee. Civil law guarantees will nearly always have a maturity date to them. Common law guarantees are perpetual. They go on forever until terminated. The only common law guarantees that will have a maturity date are guarantees that are actually signed by a bank, in other words, bank guarantees. But guarantees signed by private individuals or corporations will be nearly always perpetual. I'm sure Barclays explained that this was for the benefit of their clients to remind them that the liability was still there. But I think probably more is to the point. If you have the in addition clause and for the last 10 years you've had a new guarantee signed every 2 years, that means I now have 5 guarantees. Yeah, I can only enforce one, but if the first one is invalid and the second one there's a problem with it, the chances of one guarantee being unenforceable is not remote. The chances of 5 guarantees being unenforceable is significantly less. As I say, during the course of this clip, you'll see all of the various ways in which guarantees may become unenforceable. By the way, just before we move on to clause 3, famous case in World War I, wills. Before people would go into no man's land on the blow of a whistle, the last thing each soldier would have a hook. They put on their wedding ring on the hook and a farewell note, because obviously many of them knew they might not come back. And this fellow put on his hook a farewell message that said, "All to Mabel." Now, it's now ambiguous. Is this a new will? Mabel gets everything? Or is it a codicil? Honour all of the previous bequests and Mabel gets the residue of the estate. And of course we can't ask him because he's passed. And what you have to understand is that Mabel was not his wife. And in 1916, that was a big deal. By the way, this is also a big difference in a common law system and a civil law system. A common law system is freedom of contract, as you know, and the state has no right of interference in how you choose to leave your estate. Bill Gates, I understand, has said he's leaving nothing to any of his children and only 1 million each to his grandchildren because he thinks too much money spoils people. In a civil law system, as I understand it under French law, for example, remember Roman law, from which civil law is derived, regulates rights amongst citizens, and therefore you don't have total discretion of how you bequeath your estate. Under French law, for example, as far as I'm aware, you only have discretion over 25% of your estate. You can't favour one child over another child, and you certainly can't disinherit your children or your dependents. Whereas in a common law system, the only way the state interferes as a result of statute law is through dependency. If someone is dependent on me, they have a right to a roof over their head, clothes on their back, and food on the table. But of course, if I'm a billionaire, that is a fraction of the estate. Okay, let's move on to item 3. The guarantor shall not take any security from the borrower, and if you do so in defiance of this clause, you do so on trust for the bank. Now, if you look at the diagram that I've just drawn up here, you will see that one reason that I, the borrower, may not want to give security to the bank is because if I ever get into financial difficulties, the bank will not think twice before exercising the security and repaying the loan. And that could do immense damage to the medium-term strategy of my company. And so what I'm going to do is pass the security to the guarantor. The guarantor will give the bank what it wants, which is the protection of the $10 million guarantee in this case. I give, say, $15 million of security to the guarantor, which is either a related company to me or a company, a joint venture partner, somebody I do business with. And then, when the loan defaults, or when I go broke, my security is being held by a friendly party. Now the problem is, the thing that kills me, the borrower, is there's a good chance that it will also kill the guarantor, because presumably we are related in some way. But by the way, it's not always the case that when a company goes broke, insolvent, that all companies in the group also go insolvent. When Polly Peck went broke some years ago, they had a subsidiary called Del Monte Foods, which was an absolute cash cow, and then subsequently went through an IPO of £5.5 billion. But on the other hand, it is more common that if the borrower is in financial difficulties, so too is the guarantor. And the problem is that if you don't have clause 3, the borrower, the bank, is an unsecured creditor of the guarantor. And that guarantor may have $500 million of other creditors. And so the bank ends up, with 10 or 20 cents in the dollar. However, with clause 3, that $15 million of security that is taken by the guarantor as security for the giving of the guarantee, any money that is held on trust does not form part of the insolvent estate of the guarantor. And therefore, on the assumption that that 15 million of security is still worth more than 10 million, the bank's loan is fully covered and fully recovered. So well worth having this clause in your document. Clause number 4. The guarantee, second line, halfway through the second line. The guarantee will not be satisfied by any intermediate payment, but shall be a continuing security. The biggest voodoo phrase of all. Do not mess with this phrase. It is the way of dealing with the very unsatisfactory English law or common law of appropriations. Now, let's briefly deal with the law of appropriation. Okay, so the law of appropriations. This will save us time later on when we're looking at the appropriations clause in the syndicated loan agreement. In a common law system, the first right of appropriation is the customer's. In other words, if I only partially pay to the lender the amount of money that I owe, who decides what it is that has been paid, whether it's principal, interest, fees, and therefore, by default, what has not been paid? Well, a common law system says I have the right to appropriate what I'm paying to a lender. So, for example, let's imagine I have an unauthorized overdraft. Let's imagine you're the lender. You contact me, you're very angry, you require me to deposit, let's say, $1 million, I'm $1 million overdrawn, and I do so, and I supply the $1 million with a note attached to the deposit saying that this money is earmarked for Mr. A and Mrs. B. Well, I have appropriated the money for a purpose. The temptation of you as a lender will be to ignore my note, put the money into the account to clear the overdraft, and then dishonour the payment to Mr. A and Mrs. B. If you do that, you have breached trust and you have converted assets. You as a lender now have unlimited financial liability for all of the consequences of what you have just done. Let us suppose that $1 million for Mr. A and Mrs. B was a deposit on a $1 billion property deal on which the profit was going to be $350 million. And that deal has now fallen over, it is alleged, because you seized that $1 million in breach of the appropriation that I had made in respect of that money. If I can prove that the property deal fell as a result of that appropriation, and B, if I could prove to the satisfaction of a court that the profit was $350 million indicative on that deal, you as a lender are now liable for $350 million. What you're meant to do is send the $1 million back to me and say, please submit the deposit without the attached note, because the second right of appropriation under our common law system is the lender's. And that is why a bilateral loan agreement, never a syndicated loan agreement, but a bilateral loan agreement will always have a clause that says, if there is a partial payment by the borrower, it will be the lender who will decide whether it is interest, principal or fees. And a lender will then make the decision based on the facts at that time. If a lender knows that they will fully recover the money, it's only partially paid at the moment, then a lender will nearly always say this partial payment is interest. Because as long as a loan is performing in interest payments, you don't have to make a specific provision. It's covered by the general provision. However, if you know you're going to lose money, it's just a matter of how much and when, then a bilateral lender is likely to call it principal. Because if you call it principal, yes, you will now have to make a provision, but you're going to lose money anyway, in your opinion. If I call it principal, I won't have to pay tax, and therefore a lender will want to have the right to make the decision as it suits them. Now, in a syndicated loan agreement, you would never get a 2/3 majority lender decision on whether it's principal or interest. All banks are trying to achieve different things or have different opinions of the end result of the credit. And therefore, in a syndicated loan agreement, you will always have the FIPO clause. Firstly, fees. Secondly, interest. Thirdly, principal. And fourthly, other. FIPO, FIPO. Okay. Now, if neither the borrower nor the lender have nominated what a partial payment is for, then the common law of appropriations is applied. And this, in my personal opinion, is the worst law that has ever evolved. It is set out in a case decided in 1816, which people will otherwise know as Clayton's case, after the name of the person who fell victim to this ruling. Unfortunately, it's been around for over 200 years now, and so is not going to get overturned. Clayton's case says the following. Look at this diagram. Let's imagine we have a revolving facility, an overdraft, a revolving credit, a master ISDA facility, something of this sort, where there are inflows and outflows on the same account. Now, you can see that the opening balance is $5 million, and this is the moment when the guarantee is signed or executed. We then have a deposit of $1 million, a withdrawal of $1 million, and so on, and so on, and so on, ins, outs, and the closing balance is $5 million. And this is when the guarantee is called. Because obviously perhaps there has been a problem with the underlying loan. Now, common sense tells you that if you deposit $1 million on Monday and withdraw $1 million on Tuesday, they are related. Someone is washing money through this account. And in other words, that a withdrawal is related to the most proximate deposit. Well, Clayton's case says the precise opposite. Each deposit is related to the furthest away negative balance, and each withdrawal is related to the furthest away deposit. So all of these deposits on the left-hand side of the ledger are not related to those withdrawals. They're related to the original $5 million loan balance that was guaranteed. Now, if this was not an all-monies guarantee, I mean, this guarantee that we're looking at is all-monies, so it will capture all the new withdrawals. If this is a specific guarantee for a specific revolving credit loan, which would be the more normal case, then the guarantee is now unenforceable because that original $5 million that was guaranteed has been fully repaid, and therefore the guarantee is unenforceable. This, as I say, is a very strange feature of common law. The phrase continuing security, this is a continuing security, gets around the rule in Clayton's case. It means that the guarantee refreshes every nanosecond. You know, like a computer screen refreshes 72 times per second, 72 hertz. If you have the phrase continuing security in your guarantee, then the guarantee is constantly refreshing and captures the balance at any moment in time. And all of the ins and the outs and the appropriations law is negative, is irrelevant. It doesn't come into play. So please don't ever miss out on the phrase continuing security, and don't tinker with it. Don't start inventing new words, you know, ongoing instead of continuing, collateral instead of security. Don't. We know that this phrase works. If you start inventing, you open the door to perhaps an unsatisfactory outcome. Okay, this is a continuing security until determined by 3 months' notice in writing. Determined is a fancy word for terminated. A guarantor can terminate their guarantee at any time. I told you common law guarantees are perpetual. They go on, they don't have a maturity date. And therefore a guarantor can terminate the guarantee whenever they like. Now, of course, if they terminate the guarantee, I am pretty sure you're going to have a clause in the other contract, a loan agreement, saying that that will be an event of default if it's terminated without consultation and consent of the lender. But that's another issue. The termination of the guarantee doesn't extinguish the liability. What it does is freeze the liability of the guarantee as at the date of termination. So let's imagine we had a $10 million loan and a $10 million guarantee, but on the effective date of termination, the outstanding amount under the underlying loan is $3 million. That means the guarantor has frozen their liability in perpetuity at $3 million. Now, because of this is no longer a continuing security, this guarantee has been terminated, any deposits on this account will reduce the $3 million liability of the guarantor. So the reason that the bank needs notice, this is the longest notice period I've ever seen. Most modern bank standard form guarantees have a notice period when you terminate a guarantee of 48 hours, something of that order, to give the bank enough time to rule off the first account. In other words, no deposits will now be accepted on the borrower's underlying account. Any deposits will be on a new second account. That means we freeze the liability of the guarantor. Let's imagine that we do that. We rule off the original account, and $2 million are accumulated in the second account over the next 12 months. So I hope you're following this. The net exposure of the bank is now $1 million. The $3 million negative on the first account, the original account, and the positive $2 million balance on the new account that has been opened after the guarantee's termination. If the borrower and the guarantor now both collapse into insolvency, our proof of claim in the insolvency of the guarantor is $3 million. That means we only have to recover 33 cents in the dollar on the $3 million claim to receive the $1 million, which is actually the bank's real exposure. So a termination of a guarantee, providing you rule off the original account, is not necessarily a negative thing from a credit point of view. Now, that's the way the law works. In real life, why would somebody want to terminate a guarantee? Well, in many industries, ships, for example, media, each ship is in a separate company. So when you sell the ship, you don't. You sell the company that owns the ship and the time charter party, which is the contract that turns the asset into a cash flow. If I sell a television station, I don't. I sell the company, the shares in the company that own the television station, and so on. And therefore, if I am selling an asset by way of selling the company that owns that asset, I'm selling the ship, I'm selling the TV station, the person who is acquiring that company, stroke asset, does not want that guarantee to still be accumulating potential liability. They will want it frozen. And in the sales and purchase agreement, either they will withhold it and put it into escrow, so that the last $3 million will be paid over when the liability is no longer in existence, or they will pay the full purchase price against an indemnity to be reimbursed should the purchaser of that company ever have to pay out under the guarantee. Now, eventually, when the money in the second account equals or is greater than the amount in the first account, the two accounts can be merged, the net exposure is zero, and the guarantee is no liability, and no further liability under the guarantee. Clause 5. Clause 5 is the set-off clause, and I think we've had discussions about set-off before. I don't have much further to say about it, except this. Do you notice that this particular set-off clause says that you can mess with assets of the guarantor, whether held for safe custody or otherwise? No, that's not set off. You set off mutual accounts. You can't touch the assets of someone else unless you have perfected security. And in many countries that means you have to have registered it in a certain location within a certain time period and all of that. Now, it so happens under English law there is something called a banker's lien, which does give you the power of sale over assets that are retained. But that's not set off. It doesn't matter that you write this nonsense as long as an employee of the lender doesn't think that they're applying set off. Okay, clause 6. Clause 6 is the no competition clause, and if you have a quick read of what it says, if I have a $10 million guarantee of a $10 million loan, and I fully pay the $10 million guarantee, then I have what's called a right of subrogation. I subrogate to the rights that the lender has against the borrower. Effectively, I've purchased the loan. That means if the bank had security for the loan, I, the guarantor, having paid out the loan, I now take over that security and pursue my rights against the borrower. In other words, I step into the shoes of the lender. But this clause 6 says that if I only partially pay the guarantee, for example, let's imagine I only pay $5 million. I don't get a partial right of subrogation. I have no rights against the borrower at all. More colloquially, it's called the gagging clause. If a guarantor only partially pays a guarantee, you sit him on a chair, you tie his hands behind his back and you gag his mouth. He's not allowed to tell anybody that he's paid that $5 million. Now, if you receive money from a guarantor, you do not apply it to the loan account in the way that I've described it in this diagram. Instead, you put it into an 8888 account. All banks have an 8888 account. It's a suspense account where you put money that you don't know how to account for. For example, the insolvency of this borrower may take 2 or 3 years to work through. If we eventually do receive all of our money back from the borrower, maybe the assets are sold at very attractive prices and so on, I have to return that $5 million to the guarantor. I can't keep it. Far more likely, in 2 years' time, we discover we've lost more than $5 million on this underlying loan. I will then transfer the money from the suspense account into the loan account and apply it. Let's imagine, as a third possibility, that in the wind-up of the borrower, we eventually recover $7.5 million of the loan. I'm missing out accrued interest and fees. I'm trying to keep it followable. I recover $7.5 million of the principal. At that point, I will take $2.5 million from the suspense account and apply it to the loan, and the other $2.5 million will need to be returned to the guarantor. In other words, we don't know what the final outcome will be, and so it goes on suspense. Because as long as I have the gagging clause, the no competition clause, then I, the lender, will put a proof of claim against the defaulting borrower of $10 million. Let's say that the insolvency is paying 50 cents in the dollar. I receive 50 cents, $5 million from the insolvency practitioner under the defaulted loan. And I can then go to the suspense account, the 8888 account. I can go to the suspense account and now apply that further $5 million for a full 100 cents in the dollar recovery. I'm obviously missing out complications of accrued interest and fees and so on. If I was unfortunate enough not to have the gagging clause, then I would put in a claim of 10 million as a lender. The guarantor would put in a claim of 5 million. And the insolvency practitioner would say, well, the company has borrowed $10 million, but we have claims totaling $15 million. This doesn't look right. It will take him 24 hours to discover that the guarantor has indeed paid to the bank $5 million. You'll get a very polite letter from the insolvency practitioner, you the lender, saying, we have evidence that you've already received $5 million in respect of this loan account. We are reducing your claim to $5 million, on which we're paying 50 cents in the dollar, which is $2.5 million, which when you add it to the money in the suspense account is only $7.5 million. You've just lost $2.5 million. So that's why we want the guarantor to say they will not compete with the lender in pursuing claims against the borrower until they have fully discharged their liabilities to the bank. Well, as you can see, I've been banished from the kitchen, so back to the study. Where were we? I think we had just finished talking about Clause 6, the no competition clause. Clause 7 in this particular guarantee. Do you remember we were talking about ruling off the account when we were talking about the termination of a guarantee? It's very important that because it's no longer a continuing security that we rule off the account. For some reason, in this guarantee, the ruling off clause is not in clause 4, which is where the termination was, but in clause 7. But here it is. I much prefer to see the actual words where the guarantor gives us the consent to rule off the first account and conduct business with the borrower on a second account. But this wording achieves the same thing. My drafting preference would be for something slightly different. Let's move on to a key clause, clause 8. I've put it up here on the screen, and I have rarely seen such a badly drafted clause. There's no punctuation in it, And if you take a moment to just read this clause, I would challenge you to ever identify what it actually means. But here we go. Do you remember that in an earlier clip we talked about the difference between a guarantee and an indemnity? And we said that a guarantee is a promise to perform somebody else's contractual obligation, somebody else's contractual obligations. In other words, it's a collateral contract, a secondary contract, whereas an indemnity is a direct obligation to indemnify the lender against any loss that it may sustain. And it's not a secondary contract, it's a primary obligation as principal debtor in the penultimate line here, as principal obligor. And therefore, an indemnity is good even if the underlying loan agreement is not good for some technical reason. And we said that indemnities are therefore more powerful than guarantees. Well, in a typical financial transaction, there are 4 things that I need an indemnity for as opposed to a guarantee. Because there are 4 circumstances where actually the so-called borrower is not a borrower because it's not a loan, because it's not a contract. In other words, if the contract fails, then common law will not enforce the so-called contract. And this indemnity clause covers 3 of those 4 instances. Now, the first 2 instances is ultra vires. Ultra vires the company's power, and ultra vires the director's authority. So if you look carefully in this clause, it's talking about, I think, want of power on the part of the directors. Want of power is a very quaint English way of saying absence of power. If I was your boss and I was giving you a review and I said your performance is found wanting, in other words, I'm not happy that you're doing a very good job. So want of authority means ultra vires the director's powers. And you will then see, use the same phraseology, want of power on the part of the company. And so that means if the underlying loan agreement fails for ultra vires the company's powers, then this is not a guarantee, this is an indemnity. And the third thing for where a guarantee wouldn't work, as I think I indicated when we were talking about guarantees and indemnities earlier, is that if the underlying loan agreement is unenforceable, for example, for illegality, then I want an indemnity. And so there you have it in line 2, as a result of any failure or irregularity in respect of the money's obligations or liabilities hereby guaranteed. And therefore, illegality, ultra vires the company, ultra vires the director's powers. Let's move on to Clause 9. Clause 9 covers 2 things. Both of them are relevant where there are multiple guarantors. Now, the first of these things is that do I want the guarantee to be several or joint and several? Now, if I'm the lender, I clearly want it to be joint and several. Let's imagine that there are 4 guarantors for a $10 million loan. If they were several, then each guarantor is only liable for $2.5 million each. And a chain is only as strong as the weakest link. And therefore, if one of the guarantors fails, I, as the beneficiary of that guarantee, the lender, I will then lose $2.5 million. And the danger is that one of the guarantors may go insolvent, another of the guarantors may go on the run, if there's an individual, of course, and so on, and so I could sustain loss. If the guarantees are joint and several, Each of these four guarantors are liable for the entire $10 million. Now, I can only recover $10 million if that is my exposure. I can't over-recover. And I will go against whoever I think is the strongest, or I could go against all four guarantors simultaneously. And let's imagine that one of these guarantors pays out. That guarantor then, in common law, even though it's not written anywhere, in common law they have a right of contribution from the other three guarantors. And I don't care. I'm the lender, I've got my $10 million, I'm out of here. That one guarantor can then go and find that guy who pretends to be insolvent to find out where he stashed his wealth. He can go and find that guy who has absconded, and so on. That's their problem. I'm the financier, I've recovered my money. And therefore, I always, when there are multiple guarantors, I always want joint and several. However, in some structured financings, where the guarantors are not related to each other, let's imagine that I'm a multinational corporation and I'm in partnership with a local, weaker, financially weaker partner. It's fairly obvious that if the underlying loan goes bad, the financiers are going to come against me, the credit-worthy multinational corporation. And I don't want to expose if I only have 30% ownership of a joint venture, I only want to guarantee my proportionate share of the underlying liability. And therefore, I don't want a joint and several. I want everybody who is a guarantor to be liable for their proportionate share or for what they have agreed. And of course, who wins this argument will depend on bargaining power between lender and borrowers. Clearly, if the guarantor is related to the borrower, there's no doubt you will end up with joints and several. But clearly in structured financing, project financing in particular, there's a fairly good chance that you'll have a shortfall several guarantee as opposed to an on-demand joint and several guarantee. Now, the second feature of this Clause 9 is something that I would not be aware of how important it was, but for a consulting assignment that I did a long time ago, in 1995, after the last global crisis, which blew up in December of 1990, after that was all over and things were back to normal, one of the four British high street banks decided to conduct a security audit of all of their corporate loans. And they hired 16 consultants, of whom I was one, to drag out all of the documentation and so forth, because a lot of errors had been made in the bubbly, frothy period of the late 1980s. And for those corporate clients that had obviously survived that crash, they wanted to see how bad the condition was of their security and their documentation. And I was shocked to discover that in about 25% of their corporate loans, where there were guarantees involved, unfortunately they had made this error, the error I'm about to tell you about. The bank had four standard form corporate four standard form guarantees. A format to be signed if it was a human being, a private individual, a shareholder or director. One if there was a single corporate guarantor. Another standard form if there were multiple guarantors. And then a fourth one called an omnibus guarantee, which is technical and is not relevant for this discussion. And in 25% of the cases, they had inadvertently, whoever was responsible for the documentation, had inadvertently picked up the wrong standard form. In other words, there were multiple guarantors, but they picked up a guarantee that was designed for a single guarantor, in which case the equivalent of this Clause 9 was missing, and that is going to be fatal. Let's imagine there are not four guarantors, there are five. I'm a guarantor. I'm the fifth guarantor. And I signed knowing that there are meant to be 4 other guarantees because it's a condition precedent to the loan that there are these 5 guarantees. Several years down the track, when you're trying to enforce this guarantee against me, it appears that you failed to obtain the guarantee of one of the other people, or one of the other companies. Well, you've altered my liability. You didn't have my consent to alter that liability, and therefore my guarantee is unenforceable. Secondly, let's imagine you did get the guarantee of that other person, but halfway through the loan, that person requested that their guarantee be released, and you released that guarantee. That alters my liability. You don't have my authority to alter my liability, and therefore if you release his guarantee, you've released the other 4, automatically. Let's imagine that you got all 5 guarantees, you haven't released any of them, but one of them is unenforceable. There's a technical defect with it. Well, that alters my liability. You don't have my consent. All 5 guarantees are unenforceable. And so you can see what this clause does. This clause says that if the guarantee, you have failed to obtain it, you've released it, or it is unenforceable for some technical reason, that it does not alter the enforceability of all of the other guarantees, where there are multiple guarantors. In other words, you're getting the consent of the guarantors in advance that you may do business with the other guarantors without affecting the liability of the one that they have signed. Now, it's instructive to notice that the LMA syndicated loan agreement, there are many different versions of it. Versions where there's a single borrower, versions where there's a single guarantor, multiple borrowers and multiple guarantors. So be very careful that you're picking up the right document. And again, if you had an annual security audit, for loans that you wrote 3 or 4 years ago, if somebody has made a mistake, hopefully someone would pick that up in your periodic documentation audit. Okay, move on to Clause 10. Clause 10 is missing from the LMA guarantee, the guarantee that is embedded in the LMA loan agreement. And if I were you, I wouldn't miss this one out. You can see it's the conclusive evidence clause. It says that the amount being claimed whatever the bank says is conclusive evidence of the amount owing. Well, clearly this is a voodoo phrase. Conclusive evidence doesn't mean conclusive evidence. By the way, if it did, it would be struck out under the Unfair Contract Terms Act. How reasonable is it to have a clause in a contract that says if we ever have a dispute, then we don't have a dispute because whatever I say is conclusive? I mean, that would be unreasonable. A conclusive evidence clause reverses the onus of proof. See, in common law, the burden of proof is on he who alleges something. And therefore, because it's nearly always the lender who is trying to recover the money, it's nearly always the lender who is alleging that this is the amount owing, and therefore they have the burden of proof. So, for example, if there were premature closing of derivative contracts and so on, very technical about costing and so on, that they need to demonstrate the amount. However, let's imagine that I'm a dishonest guarantor and I'm trying to evade my liability. I might put to you a deal that, okay, under this guarantee I owe you $10 million, but here's the deal. Either accept in full settlement of my liability $4 million cash tomorrow, $4 million cash tomorrow, or if you're foolish enough to reject that, I'll put you to proof of claim for every single transaction. We're going to go back 12 years. Over the overdraft account, how many checks a day? 40 checks a day. Every single transaction, I'm going to require you to demonstrate the legitimate entry into your account. This is all in archive boxes somewhere. Now, I don't think you've made a mistake. What I'm doing is buying time. Whilst you are discharging your burden of proof and assembling the whole history of the account, I will be busy siphoning my money away. All of my friends who are invoicing will over-invoice me, and I will dissipate my money into Swiss bank account somewhere. You see, I can't do it quickly. The insolvency law of any country, where transactions are designed to shelter your assets away from your creditors, those transactions are going to get reversed. But if I have time to siphon gradually the money away, then by the time you've discharged your burden of claim, there will be no money left. Well, to heck with that. I'm the lender. I don't want to have to prove anything. I want the burden of proof to be on the guarantor to demonstrate that my claim is the wrong amount. So, you know, if you want the archive boxes, you go through it and find the errors. And of course, if there are errors, then clearly the lender has to, in the face of a manifest error, then the lender must alter their claim. This is clear. So it doesn't mean conclusive evidence. It means changing of the burden of proof. So if I were you, I would put that sentence into the guarantee, missing in the LMA. Clause 11 is the notices clause. I have nothing particular to say about that. Clause 12 is another very important clause. Do you remember I said there are 4 things for which I want an indemnity, and the clause 8 in this particular guarantee only picked up the first 3. Let's track through what clause 12 is called the survivorship clause. It will survive the termination of the guarantee. If you see this diagram, let's imagine that we have a $10 million loan, but shortly before the borrower collapses into some form of insolvent administration, they prepay the loan. They have some cash lying around, they decide to prepay this loan. The liability under the loan now goes to 0, which means the contingent liability under the guarantee is also 0. But the company now goes into insolvency, and under the insolvency law, and we'll be discussing that in another clip, how preferences work, the court adjudicates that that prepayment is avoidable preference, and therefore orders the company to pay that money back to the bank, orders the bank to pay that money back to the company. In other words, it defies the pari passu principle. The company was insolvent when the prepayment was made, and so on. That means the loan has bounced back up to $10 million. What is the liability under the guarantee? Well, if the guarantor had any sense, the moment they saw that their guarantee liability had gone to 0, they would have served a notice of termination of the guarantee. That means the guarantee's liability is now frozen at 0, which means that when the bank has to pay back the money to the company, the loan goes back up, but the guarantee stays at 0. Well, in that circumstance, I don't want this to be a guarantee, I want it to be an indemnity. And if you read the wording, in the event that any settlement or discharge is made between the bank and the guarantor shall indemnify the bank against any loss that it may sustain in the event that any security or payment made to the bank by the borrower is avoided or reduced by virtue of any provision or enactments relating to bankruptcy or company liquidations. In other words, just what I've said, the indemnity against voidable preferences. Okay, clause 13, governed by English law, full stop, we don't want any ambiguity on that. And the last clause, this guarantee shall remain the property of the bank. Now that may seem a very odd clause to have an agreement. I know one bank that says the paper on which This guarantee is written shall remain the property of the bank for up to 2 years following the determination of the guarantee, which is, in my view, a foolish way to phrase it. But it's a very important clause. Under common law, any documents that I sign, if I'm the customer of a lender, those documents are mine. And when there is no liability under them, I'm entitled to have them returned. If I repay my mortgage, not only am I entitled to my title deeds back, but I can come into the bank and ask for the actual discharged mortgage. Once the bank has discharged the mortgage, I'm entitled to physically take possession of the paper. I'm sure you'll charge me a fee for it, for the nuisance value of me making such a request, but nonetheless it's mine. There is one document that you never give back to the client of a lender, and that is a common law guarantee. You may recall in an earlier clip I said there are 4 things in finance that have to be in writing, and one of them that I mentioned was a guarantee. Or to put it absolutely correctly, a guarantee has to be evidenced in writing. That means if you ever go to court to enforce a guarantee, you have to take in the signed original. Now, it's the only document where you have to have a signed original. I mean, if I litigate a loan agreement, you never take the original loan agreement, you take a conformed copy to court. The only reason you'd ever need a signed original is if someone was alleging that that wasn't their signature. In other words, it's a forgery, it's a fake. In all other cases, you take in conformed copies. But a guarantee, it has to be the signed original. So, if you ever find a guarantee outside the safe, for heaven's sake, get it back in there. You see, I don't know how, if you're a lender, I don't know how your files work, but what I'm used to is you open up the folder, and on the right-hand side is all the low priority stuff, emails and messages, and on the left-hand side is all the important stuff, credit approval papers, loan agreements, and so on. I don't mind if there's a loan agreement in there, an original loan agreement, as long as it's not a guarantee inside the loan agreement, but you must never have a signed original loan agreement, a guarantee in the folder. Because if you ever lose it, it's like a bearer instrument. If it's it's like a $10 million banknote. If you ever lose it, you've lost your claim. And some of these guarantees are 10, 15, 20 years old. And the file has been dropped, you've left something on the photocopier glass and the cleaner comes along, a work experience student, and you say, destroy any correspondence more than 10 years old. And they see a letter of guarantee, 15 years old, and they shred it. For heaven's sake, get it in the safe. And if you did an annual security audit, if you were missing the guarantee, whilst the company is still solvent and you have a good relationship, you can probably rectify the problem and go to the client and say, listen, do you mind re-executing the guarantee? On a relationship basis, we're all good friends. But if you discover this problem when the company is on the verge of insolvency, I think the discussion is going to be about the terms of your bailout loan. Absolutely critical. And for example, that clause 12 that we're talking about, do you remember he terminated the guarantee? But there's an indemnity if the court orders you to repay that money back to the company. Let's imagine that you received the repayment of the loan, the guarantor terminated the guarantee, and then showed up at the bank and said, the liability under the guarantee is now 0, I want the signed original guarantee, give me back my document. As absent this clause 14, he's entitled to do it. You give the guarantee back, and then a month later, the court orders you to repay the $10 million to the company. You'd be going to your boss, and you'd be saying, boss, I have some bad news, but then I have some good news, but then I've got more bad news. And the boss says, what's the bad news? The court has ordered us to pay the $10 million back to the borrower. And he says, yeah, that's bad news. But you said there's good news. And you say, yes, well, in clause 12, we have an indemnity where this creditworthy guarantor is still liable. This clause 12 survives the termination of the guarantee, and it's an indemnity to reimburse the bank for any loss that it might sustain on that 10 million loan. And your boss says, great, that's fantastic. But you said you have more bad news. Yes, we no longer have the guarantee. We gave it back to the guarantor. That means the night before the court hearing, you have to ring the guarantor and ask him if he would kindly bring in with him that signed original guarantee that you let him have back. And when he rings his lawyer, and the lawyer discovers that they are in possession of the signed original, there will be a ceremonial document burning party on the night before your court hearing. I'm sorry to caricature it, but I think you've got the message. Signed original guarantees are unique instruments in a common law system. They must never leave the safe. I hope that message is well received. Okay, well, listen, I think that concludes what I have to say about guarantees. You will find in the notes the reconciliation here between the guarantee that we've just gone through in this clip and in the notes with the one that's embedded inside the syndicated LMA loan agreement, where you can see those cross-references are, and I'll allow you to explore that at your leisure and pick them up and so on. Okay, well, thank you for listening in. Ciao.